Ladies and gentlemen, this is a summary and review of the little book on legal writing by Alan Dworsky. We are on chapter 14, Argument. And this is pretty good because I think I'm going to be making a lot of arguments. So in particular, I'm very interested in this chapter. Let's get going. A good objective discussion of a legal issue and a good persuasive argument on the same issue have much in common. Both require a mastery of the facts. Both require good research, writing, and analysis. Even their structures are similar, but you need to make several specific changes when you switch from discussion to argument. This chapter explains those changes and the strategy you need to make your writing persuasive. Borrow from the format of a brief to make a memorandum of the law more effective. Appellate briefs and memoranda of law are the documents lawyers use to argue to courts. A brief is submitted on legal issues to an appellate court. Each jurisdiction has a statute or court rule determining what a brief must contain and in what order. The statement of facts and the arguments are always at the heart of a brief. Sections for questions presented or issues, a table of contents, a table of authorities, and a conclusion are always included. Sometimes other sections are included, such as a statement of the case, opinions below, jurisdictions, statutes involved, and the summary of the argument. Next, tell a compelling story in your facts. This sounds good. Let's read it. In our system of justice, courts are supposed to decide cases in keeping with existing statutes, administrative rules, and case law. But because reality is infinitely varied and complex, often a dispute won't fall squarely under a particular statute, rule, or case. If it does, it gets settled and settled early. Disputes that become litigated cases are usually disputes in which it is unclear what law applies or how the law applies. The best way to get the court on your side is to tell a compelling story in your statement of facts. Writing a persuasive facts is a subtle art. You can't just haul out the heaviest adjectives in your vocabulary and dump them on the page. The trick is to write with persuasive facts that appear objective. You want the judge to feel that they're simply reading what happened. Dude, what a freaking, that was some gold nugget right there. Next, start with your strongest argument whenever possible. If a comedian's first joke is funny, you laugh more easily at those that follow. If a band's first song is good, you listen more generously to those that follow. If your first argument is strong, judges will read those that follow with more attention and respect. If it's weak, they will assume what follows is even weaker. Their interest will flag, they may skim, they may even stop. Once again, start with your strongest argument whenever possible. Next, argue issues one at a time using CRAC. Like an objective discussion of an issue, an argument of an issue should also have a CRAC structure. Almost everything said about CRAC in the chapter of office memoranda applies equally to CRAC and argument. CRAC is a flexible tool for organizing your arguments, not an ironclad mold you must squeeze every argument into. Adapt it to your particular argument. You got to be creative, folks. Next, refute opposing arguments within the framework of your arguments. How interesting. Arguments can be attacked at 3 levels. The first level is simple accuracy. Search your opponent's argument for the following. 1, a misrepresentation or admission of an important fact. 2, a misquotation of an authority or an accurate quotation of an authority that's misleading because it's taken out of context. 3, reliance on a case that's been overruled or a statute that's been revised or appealed. If you find one of these, point it out to the court, but only if it's important. Don't nitpick. The second level is the content of the argument. Point out errors in reasoning with an opponent's arguments or inconsistencies between 2 or more arguments. Distinguish your opponent's cases. Show that the statute was never meant to apply to cases like yours. Next, choose a few good arguments. Not a bunch, choose a few good arguments. Next, prefer a simple argument to a complicated one. Dude, isn't that so nice? Prefer a simple argument to a complicated one because that helps the judge understand. It helps the judge understand the simple argument. Next, offer the court an easy way to rule in your favor. Judges are like everybody else. They want to avoid difficult decisions. They want to avoid unnecessary conflict and controversy. How interesting. Next, add a policy argument if you've got a good one. You won't score any points with a vague argument that something is consistent or inconsistent with public policy. You must tell the court exactly how a decision in your favor would be good for the real world or the judicial system. How interesting. That kind of ties back to having a persuasive argument. Next, gear your arguments to the standard of review. First year law students, the standard of review often seems like an obscure, abstract legal technicality, but it is often foremost in the minds of appellate judges, and it can mean life or death to an appeal. The standard of review determines how hard it will be to get an appellate court to reverse the decision of a trial court or administrative agency. Next, rely on a lower court's opinion in your case if it's well-reasoned or well-written. That's pretty self-explanatory. I'm not going to read more on that. Next, write in a forceful but reasonable tone. How interesting. You've got to be forceful. You've got to be forceful in order to have a strong argument, but you also have to be reasonable. So don't go crazy, but just be reasonable and forceful simultaneously. Next, omit needless introductory words at the start of arguments. That's pretty self-explanatory. We're not going to go over that. Next, attack opposing arguments, not opposing lawyers. This is a very good point because, you don't want to make enemies in the court, and you're going to be working with these people for the rest of your life. And, most likely you're just going to be working in a particular state. Dude, I'm not a lawyer, so I don't know, but you don't want to make enemies with other lawyers. Finally, and this is the final point of the final chapter, well, not the final chapter, but chapter 14, because chapter 15 is just a conclusion. Never risk your credibility. If you lose your court's trust, you will lose the case. Honesty is the best policy. Don't hide anything. Give the facts from your client's point of view, but make them accurate and complete. Don't overstate your arguments. Push them only as far as the facts and the law will allow, and not one step further. Acknowledge your weaknesses where you must, and show the court how they don't really hurt your case. Oh, dude, what a fantastic way to end. And that was chapter 14, argument. Yeah, chapter 14, argument. Anyways, that's it for that. We're going to do the conclusion, and we're going to cite them books, but that's going to go super quick. Bye-bye. Remember, kiss that like button, kiss that subscribe button with your finger, not your lips, but if you want to kiss it with your lips, you can, but it probably won't register on your phone. So kiss it with your finger, kiss it with your finger. And then if you're really interested in this work, go to the Miyakizilla Patreon page and support the work. All right, thank you. Bye. If you're an independent and you care about being represented, even more so if you're frustrated and you feel like you're not represented, the whole point of this project, the whole point of this content is to help independents feel like they've got a voice, feel like they've got somebody fighting for them. And so that's what this content's about. If you're interested in supporting this, go to the patreon.com/Miyakizilla Patreon page and consider supporting us for $2 a month. That's all. All right, thank you very much. Bye.